Hi, I'm Mooney and I'm a lawyer. I make video essays in my spare time for fun. That's right, this is what I do for fun. You may already know me from my video on Nintendo's overprotective behavior regarding its intellectual property. I'm interrupting my regular release schedule to address this topic, and so please pardon the brevity, disorganization, and unsophisticated editing. I literally wrote this script in an afternoon. Please also understand, nothing in this video should be taken as legal advice. Thank you. A viewer recently brought the PointCrow situation to my attention. For those of us not in the know, PointCrow is a YouTuber and Twitch streamer who has garnered substantial success playing and modding Nintendo's The Legend of Zelda: Breath of the Wild. Nintendo recently issued copyright strikes to PointCrow's YouTube channel, taking down a large number of his videos, thereby threatening the future of his channel. PointCrow, in response, made a video with a script reviewed, as he states, by his lawyers. And boy, let me tell you, it sure does read like a lawyer's statement to me. I'd like to go through the statement with you together and break things down from a lawyer's perspective. In so doing, we will come to understand why Nintendo has acted with such apparent harshness, while also learning what the rest of us can do to avoid ending up like PointCrow. We will also look at how intellectual property law works, and then we will do the unthinkable. We will actually read a terms of service agreement together. Well, parts of it, the relevant parts. Let's get right to it then. We will begin first by hearing what PointCrow has to say. Chapter 1. The Legality of Mods and the Fair Use Defense. PointCrow starts off his video by stating that he makes videos playing games, sometimes in strange ways. The term strange ways, he continues, includes the act of modifying or modding games, and one of these mods turned The Legend of Zelda: Breath of the Wild into a multiplayer game. He then states the following.
I have never encouraged piracy of Nintendo's games. The mods that I've commissioned are not being sold, and all of the code is custom, meaning that they are free of Nintendo assets.
Why does he say this? Or rather, why are his lawyers encouraging him to say this? To understand why, we must first look at fair use. Fair use is an affirmative defense. It is a protection you can use to defend yourself in court. The only place you get to make your fair use argument is in court if you've already been sued and are using it as a litigation defense. And as I like to remind my clients from time to time, litigation is expensive. It's very expensive. Fair use has 4 elements, each of which must be considered to determine whether one truly has fairly used someone else's IP. Number 1, the purpose and character of the use. Number 2, the nature of the copyrighted work. Number 3, the amount and substantiality of the portion used in relation to the copyrighted work. And 4, the effect of the use on the potential market. But in practice, we can boil this all down into just 2 tests. Is the copyrighted material being used for scholarship, education, parody, or news reporting, or for more of a commercial purpose? And number 2, is the use of the copyrighted materials de minimis and transformative, as little as possible and changing a lot? PointCrow says the mods I've commissioned are not being sold. His lawyers want you to know that the use isn't commercial. PointCrow says the code is custom, free of Nintendo assets. His lawyers want you to know that the mod's use of copyrighted materials is de minimis and transformative. The problem is, effect on the potential market is not limited to mere commercial exploitation of the derivative work itself. Selling the mod in violation of Nintendo's copyright is not the only way a mod could affect the potential market. And speaking frankly, the mods PointCrow has made, commissioned, or used are almost certainly not a de minimis use and almost certainly not meaningfully transformative. Earthbound's manipulation of a tiny sample of Sgt. Pepper's Lonely Hearts Club Band Reprise into the very weird-sounding Megaton Walk is arguably de minimis and transformative. The Breath of the Wild multiplayer mod is still very evidently Breath of the Wild, and the game is virtually identical, except now it's multiplayer. You see, in the realm of video game intellectual property, there is almost no gray area more dangerous for both developers and content creators than that of modding. When we think of modding, we think of adding Thomas the Tank Engine to Skyrim. But in the legal sense, modding is any modification of a game. And modding is a very large bucket. It includes horse armor, but it also includes multiplayer mods, and for that matter, it includes update patches, DLCs, skins, aimbots, wall hacks, and cracks. A modification that cracks open software copyright protections. These are all mods by law. Modding is already looked upon very unfavorably by courts, and modding is actually becoming slowly less protected, not more. Right now, courts generally understand that unless permission to mod is explicitly granted by a developer, modding is prima facie copyright infringement as a matter of course. Put simply, virtually all mods are copyright infringement by law. Under U.S. Code Title 17, Section 106, the exclusive rights of copyright holders include creating derivative works. And the problem with creating a mod, a modification of a video game, is that all mods are understood to be derivative works of an original work. Let's take a look at the controlling case law with regards to video game mods. MicroStar v. FormGen Incorporated. In this case, MicroStar, a computer software distributor, downloaded 300 player-created levels for the game Duke Nukem 3D and mass-produced them on a CD-ROM to sell. The Ninth Circuit found that these player-created levels constituted something akin to sequels, which told, and I quote, "new tales of Duke's fabulous adventures." As copyright law gives copyright holders the exclusive right to make sequels or derivative works of their original work, this holding meant that all mods going forward are essentially derivative works. This case law is still the controlling decision with regards to any game modifications, ranging from things as small as game updates or patches, to DLCs, to machinima, and even aimbots or wall hacks. All modding is necessarily derivative work of an original work, and so the courts say, if you mod without permission, you are infringing on another's copyright. End of question. Now, it's true that some companies openly court a modding scene. Valve, for example, or Bethesda or Blizzard with its map editor. But Valve, as the creator of an engine, has an incentive to promote use of its engine via a modding scene. Bethesda and Blizzard encourage modding in order to extend game sales and shelf life, and give permission and tools to do so. But not every company has those same incentives. And even then, it is not that these mods aren't copyright infringement if permission isn't granted. It's that the copyright holder has chosen not to enforce their rights in their copyrighted work. And of the major developers, the only one that doesn't enforce those rights is Valve, and this is likely because Valve is privately owned. Thank you, Gabe. In the law, there is only a tenuous distinction between modding and hacking or even cracking. Going back to Blizzard, let's look at some case law again, MDY Industries, LLC versus Blizzard Entertainment Incorporated, where the Ninth Circuit found that a modification allowing automated actions by player characters in Blizzard's multiplayer online role-playing game, World of Warcraft, infringed Blizzard's copyright in the game, specifically that the sale of the botting software Glider was a violation of Blizzard's end-user license agreement in terms of use governing World of Warcraft. In other words, Blizzard might allow mods in Warcraft 3 through its editors, but it doesn't allow botting in World of Warcraft. And the mechanism of action it uses to enforce rules against botting is that botting is a modification of World of Warcraft that infringes upon Blizzard's copyright in violation of its license agreement and terms of use. This is the reason why even PointCrow's Mario Odyssey and Pokemon Violet videos were claimed. It doesn't matter that these aren't Breath of the Wild videos, that's not the problem. Nintendo fired off a warning salvo with the Breath of the Wild video claims. And when Nintendo saw that the appeal came back instead of some communication from the content creator, I imagine they decided to go ahead and enforce their rights on a larger scale instead of holding back. PointCrow also draws specific attention to the multiplayer mod he was using, one which he was responsible for commissioning. A multiplayer mod of a single-player game is a big no-no, not just for Nintendo, but for most large developers because the consequences and interactions possible with a multiplayer mod are substantial. A multiplayer mod is sophisticated enough where it enters almost into that crack territory, where the mod enables serious functionality that Nintendo does not intend for the game to have. Now, this is beyond a mere derivative work that infringes copyright. There are security concerns here, intellectual property concerns with regards to proprietary technology, code, and hardware interactions. And Nintendo is fiercely protective of its intellectual property for very good reason, relating to that enormous value of its intellectual property and the unfortunate risks that are a result of the extremely dysfunctional nature of American IP law. I have a whole video about that, by the way. You can see my Nintendo video for more information. Multiplayer mods are an extremely hard line in the sand for a lot of big developers for precisely this reason. Now, as PointCrow, points out, His intention isn't to encourage piracy. His intention isn't to sell anything like in the Blizzard modding case, but he is the one who commissioned this multiplayer mod for $10,000 US. It exists because of his direct financial involvement. And in this case, there's a lot of very real risk here for Nintendo, which translates into really big potential problems for PointCrow. I'd argue he's even getting off a little lucky here, as Nintendo could very well have gone right for the jugular and fired off a lawsuit. Take-Two Interactive, the Grand Theft Auto people, have a history of doing exactly that and just firing the lawsuits right out of the gate. There have been a lot of multiplayer mod takedowns in the past too. This is not nearly the first time this has happened pursuant to the exact same logic we are looking at. This isn't even Nintendo's first time doing this. Here are just a few quick examples. In 2002, Blizzard sued the developers of BnetD, an open-source program that let gamers play Blizzard titles on a non-Battle.net service. In 2015, Microsoft dropped the hammer on Halo Online, an online multiplayer mod for Halo. Also in 2015, Take-Two Interactive sued the developer of a GTA 5 multiplayer instance mod by the name of NTA Authority, alleging that NT Authority's contributions to the code of this GTA 5 multiplayer instance mod inadvertently provided resources that allowed for piracy. Okay, but there are also tons of multiplayer mods that exist, right? Games from Stray to Elden Ring to Subnautica to Skyrim to RimWorld have multiplayer mods. Well, some of these mods are explicitly okayed by developers. Other mods of this nature are in violation of end-user license agreements, but the developers aren't enforcing the copyright because the potential cost, risk of liability, and market damage is not worth the bad press and legal expense. Nintendo is larger than stray developer Blue 12 Studio by orders of magnitude. Nintendo stands to lose much more than Blue 12 if a mod opens up some unintended hardware interactions, or security issues, or creates more knowledge of how Nintendo's software works so that it can be more readily copied by hungry competitors or disassembled. The cost associated with these risks is much higher than the cost of some simple bad PR or legal expenses, and so Nintendo necessarily makes the decision to enforce their rights every time, based on the legal theory that their legal team operates under. And the larger the company, and more valuable their assets are, the more likely that company is to make the same decision as Nintendo, or Microsoft, or Take-Two. Chapter 2. Guidelines versus End-User License Agreements. In PointCrow's lawyer-approved statement, he cites two different documents. The first document shown is titled Nintendo Game Content Guidelines for Online Video and Image Sharing Platforms. The second document that PointCrow shows is the Nintendo Switch Support End-User License Agreement. Now, the first document, the Guidelines, explains how Nintendo will not object to use of gameplay, footage, or screenshots, provided you follow some basic rules. This includes rules concerning monetization and rules concerning what kinds of content are encouraged and not encouraged. This is not a very long or detailed document because it isn't meant to be. Have you ever seen the movie Pirates of the Caribbean? There are rules and there are guidelines, and the last bullet point in the first section of the guidelines explicitly states, "We reserve the right to remove any content that we believe is unlawful, infringing, inappropriate, or not in line with these guidelines." This is not a license agreement. This is not a law. Nintendo doesn't owe you anything here. Nintendo gets to decide what these guidelines mean. Your content that uses their IP exists at their mercy and is subject to their interpretation. PointCrow then cites to the FAQ of the guidelines, which states that Let's Play videos and game reviews are within the scope of the guidelines. But again, with the guidelines thing, Nintendo decides what that scope is, and it doesn't need to consider your interpretations at all. Remember Valve in the previous chapter? How Valve chooses not to pursue copyright infringers by choice? This is Nintendo doing just that. This is Nintendo offering guidelines to exceptions that it can unilaterally withdraw at its leisure if you violate the principles of its social contract with you. And this is written in relatively plain language right in the FAQ. Question 11. What do you mean by content that is unlawful, infringing, or inappropriate? Examples of unlawful, infringing, or inappropriate content include but are not limited to content that incorporates Nintendo intellectual property and Number 1, violates applicable laws. Number 2, infringes the intellectual property rights of Nintendo and/or features pirated Nintendo software. But here's the thing. Everything we do as content creators that utilizes another's intellectual property is arguably an infringement of their intellectual property rights, except for content that might fall within the legally narrow scope of fair use. We YouTubers making Let's Plays and haha funny challenges and bone-dry video essays about law, we aren't IGN or MinMax with two N's. Our content is arguably always infringing. These guidelines exist to show us where the line is that we can walk, without being hammered by an IP owner. But the line is drawn at the IP owner's whim, and it can be moved to the place where the law actually physically places it, which is way in favor of the IP holder in comparison to what we believe it to actually be as the audience. We'll discuss more about the dysfunction and deficiencies of IP law in the next section of the video, but let's get back to our extremely boring documentary evidence first. The second document that PointCrow refers to is the End User License Agreement. For brevity's sake, I will refer to End User License Agreements as EULA for short. That's right, I'm actually going to force you to read one of these awful things with me. The Nintendo Switch EULA that is linked to by PointCrow has 8 articles, but the only relevant article, thankfully, is Article 1, the license grant. In this license agreement, we are given a license, almost like a driver's license, which gives us permission to play this Nintendo Switch system if we agree to the terms in Article 1. And of these terms, we acknowledge, in item number 2, that the license is non-exclusive and can be withdrawn at any time by Nintendo. In item number 3, that the software cannot be used for commercial purposes. In item number 4, that we cannot copy, duplicate, publish, transmit publicly, lease, modify, or reverse engineer the software. And in item number 5, that we cannot illegally modify the game system itself, the peripheral equipment, or the software, and may not use any peripheral equipment of this Nintendo game system which is not authorized by Nintendo. There is also a Nintendo Switch Family User Agreement, that is, a EULA that encompasses the entire body of the Switch family of devices. This agreement is also in effect to my knowledge, but is not cited to by PointCrow. It contains many of the same provisions as the first EULA, but worded slightly differently. It makes clear in particular that content obtained through the use of an unauthorized device, or through the unauthorized modification of console hardware or software may be removed. So here's the deal. We're exiting the purview of my understanding a little once we start to look into the subject of hardware. I will readily admit that I could be wrong about this specific point, so if you are an attorney with experience in this specific field, please correct me in the comments. But if you're using a capture card or a device of this nature to stream to Twitch or post to YouTube, that's not strictly allowed as per Nintendo's EULA either. It's tolerated at Nintendo's mercy via the guidelines, but the conditions set up by Nintendo allow it to remove that toleration at any time and be legally in the right. Nintendo isn't the only company that does this. Microsoft also notes in its Xbox EULA that utilizing unauthorized accessories is a violation of your license, and it also specifically lists what authorized accessories means. And Sony's EULA is the harshest and most detailed of the three by far, going so far as to make it clear that all of its restrictions are construed to apply to the greatest extent permitted by the law in your jurisdiction. What does this all mean? Well, when PointCrow shows that circular diagram where the big circle of the game content guidelines modifies the terms of service circle for content creators, that's not quite accurate, though I would probably make the same argument if I were in his position. A better analogy is something like this. The terms of service is the law of the country of Nintendo, and the guidelines are limited diplomatic immunity. Nintendo recognizes your value, and so you have some leeway that is granted to you. But this leeway can be withdrawn at any time if you cause trouble. And trouble is whatever Nintendo or any other company you substitute them for decides that trouble means. Which brings us to an important point that I think all of us content creators should always keep in the back of our minds. And that is this. Chapter 3. We are ever at their mercy. PointCrow states towards the end of the video that Nintendo has demonstrated that they will ignore their own policies and licenses to selectively enforce their intellectual property. He continues by stating, no matter how transformative or according to their public guidelines you are at risk. Here's the bitter pill we all need to swallow. All of us content creators making video game content on YouTube or Twitch, we are always at risk. The way intellectual property laws are set up means that really, fair use is much more limited than we all think it is in effect. There is a tenuous social contract we content creators subscribe to when we make content. If we don't cross the lines in the sand, then we are permitted to exist in exchange. And the social contract exists because it's really the only safe way that a company can allow for the use of their IP by streamers or YouTubers without risking the integrity of their intellectual property rights as a whole. The Game Content Guidelines document provided by Nintendo is not a license agreement, and it is not a formal contract of any kind. And neither are any other company's game content guidelines, whether that's Sega or Microsoft or Epic. Nintendo's game content guidelines are actually about industry standard. These content creator guideline documents are a benevolent offering from companies that are not required to give any ground at all to us content creators. PointCrow says, what they've demonstrated is that they, meaning Nintendo, will ignore their own policies and licenses to selectively enforce their intellectual property. But the legal reality is that this is the other way around. Nintendo is constantly ignoring their right to enforce their intellectual property rights so that you can post videos that they haven't claimed yet. Their licenses and policies do not protect you, and they do not protect me. They protect Nintendo. And it is the same way with any other company, varying only depending on the legal theory that they subscribe to. In conclusion, look, the right time to ask Nintendo to talk is before you file your appeal of their 4-video gentle warning takedown, and not after your appeal fails and your entire channel has been lit up like the 4th of July. And if you or any other YouTuber is going to do something like offer a $10,000 bounty for a multiplayer mod that you do not have permission to make, the time to consult your lawyers is before you offer the bounty, so that they can tell you not to do it, and not after Nintendo's legal department throws you off of Hell in a Cell and plummets you 16 feet through an announcer's table. This is a lesson we should have all learned by now. We've already seen this exact same thing, down to even the way the video takedowns occurred with the creator of Super Mario 64 Online. Do not make a multiplayer mod of a Nintendo game without express permission, not even if it's really cool and you would really like to do that. Not even if it would lead to awesome content for your YouTube channel. I apologize, especially to PointCrow, if all of this sounds really harsh and even a little mean-spirited, as I absolutely love his content and I think he's a great, wholesome content creator. The kind of wholesome content creator that the YouTube platform needs more of and that we should encourage. I love the idea of a multiplayer mod too. But no means no, guys, and it's well within Nintendo's right to say no and then act when we choose to do something anyway. I don't like that this is the way things are. If you don't either, the problem, and I've always maintained this in all of my legal videos, is not any company or entity per se. The problem is the law. We can talk about whose fault that is, and what might need to be fixed someday in a different video. I can't tell you what happens next in this legal story, but there's a possibility it will get very ugly. There are commenters on PointCrow's video who totally misunderstand the character of his statement. This is a defensive play. I don't personally suspect that PointCrow is preparing to sue Nintendo. In fact, I believe the opposite is possible. If there's anything to take away, let this be a lesson to all of us who make content on YouTube, Twitch, or elsewhere. If you use another's IP for your livelihood, you do so at their mercy. And you do so at your own peril. That is the bottom line. It is the way the law encourages IP holders to behave. It is as true for PointCrow as it is for you or for me or any other content creator. We are here and always have been at Nintendo or Sega or Sony's mercy. I've been Mooney. Thank you for tuning in to this very special episode of Moon Channel.